Alright, Vinny Maletti here, Maletti Law, the strongest name in the law, down here in beautiful Savannah, Georgia. If you saw my other video before this, I attempted to do this inside my house, nice and peaceful, in my office, in my home office, but my dog had other plans. He decided I needed to walk him and do it outside. He figured he would just distract the hell out of me on my house while I was doing this. Alright, so here we go. So, the purpose of this video is just to have kind of like a little discussion on what happens, during the process of a claim. So as an attorney, I kind of, you take for granted a lot of times what, you take for granted like the actual process, right? So like a normal person wouldn't understand, the defenses, how the process works, how it goes back and forth. An attorney, obviously I do this all the time. I've had 1,100 cases, so it's not difficult for me to for me, I'm like, whatever, it's routine, right? But I figured this video would be helpful in disclosing how the process generally works. All right, so first and foremost, you have the actual complaint, right? You file the complaint. Think of it as like a volleyball match. One side lobs the ball, that's a complaint, right? You discriminated against me. The other side hits the return back, says, no, I didn't discriminate. Here's a non-discriminatory reason why I did what I did, and this is why. Boom, other side gets it. No, that's a lie. Here's my proof. Boom, hits it back. So it goes back and forth 17 times until, somebody obviously, until something hits, right? Until someone makes a decision. But that back and forth sometimes takes time. Sometimes it's a big, long process. And sometimes, you kind of stray in directions that you're not expecting. So, for instance, you might talk about the focus might shift on someone else's behavior. The focus might shift on that, statutory things like, I don't know, your claim is late or your claim doesn't meet certain points. So this video will kind of walk through what do I got here? I got like 1, 2, 3, 4, 5. I pointed out like 6 defenses here, like 6 common defenses I kind of wrote out. And I'm holding my hand up so I don't like tie the dog up with a leash. So I have 6 common defenses that you'll see often, right? That you'll discuss on these kind of cases. So again, you're aggrieved, you have a discrimination case, you sue your employer, and the employer pushes back on certain things. So like the first comment, the first pushback will be simply that, we did what we did. It was a non-discriminatory motive. Essentially, we were right to do what we did, and it was a non-discriminatory basis. So in other words, I didn't fire you because you were black. I fired you because you sucked at your job, or I fired you because you did these naughty things, and here's the proof, right? So there was a non-discriminatory motive in what you did, in what the plaintiff did. That's the first defense. Second defense is, the employer did what they did to advance some kind of business policy or some kind of rule. So for instance, let's just say, advancing a business policy, I fired you because of anti-harassment. The plaintiff said something to somebody else which was naughty or did a behavior that wasn't nice, and they had to be, let go because of some kind of anti-harassment policy or put somewhere else in another company. So it was the policy that justified what you did. It was a policy that justified what the employer did. So unless that policy is discriminatory, they will get what's known as the business judgment rule. They'll get like, what's what I'm looking for? Like credibility, like their position will be credible if it's like proper business judgment that's non-discriminatory. So remember, the first is a non-discriminatory motive. The second is the rule of policy advances a particular business purpose. The third comment could be, well, the employee facilitated the conduct. So let's say you have a sexual harassment claim. The employee says, hey, Vinny Maletti discriminates. Well, let's use my dog. Flex discriminated against me, therefore I'm entitled to damages. Well, what if I was flirting with Flex? What if the person was flirting with Flex? Is it still sexual harassment if you're flirting with them, right? So that's a question. So that's a very common defense, that the employee welcomed the conduct and participated. Another defense, common, not as great, but it could happen, it could be helpful, is the employer had no idea what was going on. So you had a manager, I don't know, an off-site manager that does a whole bunch of naughty things, does a whole bunch of discriminatory actions, calls everybody foul language over the phone, blah, 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 but no one ever reports him. So the employer had no idea that this guy was doing this and had no opportunity to act on it. So that becomes another defense, that the employer had no idea. Then you have like a lot of like standardized defenses So for instance, then you have like a lot of like the statutory defenses. So for instance, like, does the law even apply? So sometimes like you have a law that, say like the ADA, it applies to, 50 companies with 50 employees or more, and you only have 5 employees. So maybe the ADA doesn't apply, right? So I have like my, gotcha, the leash went on his paw. So let's say you have the ADA. So the ADA doesn't apply. You have 5 employees, you don't have 50. So then you have that defense that you fall outside of the statute. Statute doesn't apply. So you don't have a claim, right? Another one is whether the claim is timely. Sometimes, I have most employment statutes, most state claims, probably like 2 or 3 years that you could bring a lawsuit for discrimination. I can't remember off the top of my head because I work in so many states, but most states like 2 or 3 years. Go to Google search, it's very easy. And sometimes you don't bring the claim, I don't know, for 4 years, for 5 years, or the wrongful acts happened so long ago that you're out of the statute to bring the claim actually. So that's another defense that people have. Another defense they have is that you're already out of the statute. So what are we up to? We're up to 6 now, right? We're up to non-discriminatory motive. You're up to the policy advances the business purpose. Maybe the employee welcomed the conduct, number 3. Employer didn't know, number 4. Does a particular law apply, number 5, and number 6 is whether it's even timely. So the final one I'll talk about also, which probably could also fall under the non-discriminatory motive, but the final tactic you will find and defense you will find is that the plaintiff essentially is not credible. The plaintiff is just outright lying, and the plaintiff is outright lying because of these particular actions they did. So you have a plaintiff that says, you fired me for my attendance because, I don't know, I'm a female. You hate female employees, and you don't give us the proper time of day, and you're using the attendance policy as a sword to fire me, but you really fired me because I'm female. So you look at her past behavior, you look at things she's done. Does she have a history of attendance issues? Does she flake on other things? Does she miss all kinds of other points? Or just anything that supports the notion or the suggestion or implication that this particular person, this particular plaintiff, in fact violated the policies, or in fact participated in the conduct she's alleging that is like the issue now, whatever the case is. So a person's character goes into question, and it goes into whether or not they're trustworthy, whether or not you can believe them, whether or not they have a credible case. So a lot of times you'll see performance issues being raised as a defense from employers. Again, this comes up a lot of times in a non-discriminatory motive. You were terminated because, you were really terminated because you were a poor performing employee, not because of race discrimination. And here's all your past acts that we have records of. Or in the event that, say someone quits the job, the employer might come back and say, well, you knew the writing was on the wall that you were going to be terminated, therefore you need to go. Therefore, like, when you left not really because you felt aggrieved and you were constructively terminated, but you left because you saw the writing was on the wall and you were going to be terminated at any moment. So that is also another reason. So I hope this video was helpful. I'm sorry that it's so crazy and all over the place, but I have a extremely needy dog who every time I speak thinks I'm talking to him and thinks that this is playtime for him. So I need to keep him occupied, so I have to walk, and I have to look like a psychopath in the street, holding a phone in one hand, a sheet of paper in the other, with a dog who's wrapping me around in a circle with this stupid leash. So always have a life of purpose. All right, everybody. So look, I hope this was helpful. If you have any questions, concerns, comments, you can certainly reach out to me, leave in the comment section below. And as always, yours in laws, love, and lifts. Always stay unusually motivated, keep driving, and have a beautiful day. Signing out from beautiful sunny Savannah, Georgia. Dog officially has me now in total tied up. Gonna go in circles. Have a good day.